Those who are not in favor of the motion, those who are not in favor of the motion, please raise your right hand.
Sa pagpapatuloy sa pagtalakay ng House Justice Committee sa mga articles of impeachment complaint na inihain laban kay Vice President Sara Duterte, tila may pinapahiwatig si House Committee on Justice Chairperson Luistro laban sa mga anyay pantasya at imahinasyong iniuugnay sa impeachment proceedings.
And lastly, alam mo minsan, nasa Shangri-La ako, nakita ko si Ann Curtis. Ang ganda-ganda pala niya. You know, may desire sa loob ko na nag-init talaga. At na-imagine ko na lang kung anong pwedeng mangyari. Pero siyempre, hanggang imagination na lang yon. Pero, di naman siguro ako pwedeng kasuhan dahil kung ano-ano yung na-imagine ko eh. Thank you very much, Madam Chair.
Sa kanyang opening statement, binigyang diin ni Luistro na ang pagdinig sa impeachment laban kay Vice President Sara Duterte ay hindi isang sinihan o palabas na komedya, kundi isang seryosong proseso ng Kongreso. Sa botong 54-1-0, itinuturing ng House Committee on Justice na sufficient in substance ang fourth impeachment complaint laban kay Vice President Sara Duterte o ang Attorney Cabrera complaint. Parehong nakakuha ng botong 54 na pabor, isa na hindi pabor, at 0 abstention ang motion for sufficiency in substance sa Father Sabala et al. Impeachment complaint at sa reklamong isinumiti ni Attorney Nathaniel Cabrera. Formal na padadalhan ng notice ng komite si Vice President Sara Duterte at bibigyan ng 10 calendar days ang kampo ng Vice Presidente para sagutin ito. Ang desisyon ay ginawa matapos isang tabi ng komite ang unang reklamo at aprubahan naman ang withdrawal ng ikalawang complaint laban sa pangalawang Pangulo. Kasama sa mga paratang ang umano'y maling paggamit ng confidential funds, issue sa SALN, madrigal affidavit, grave misconduct at aligasyon ng paglabag sa saligang batas. Kasabay nito, muling umingay ang usapin tungkol sa sinasabing bilyong-bilyong bank accounts na ibinabato ni dating Senador Antonio Trillanes. Sa pagbubukas ng pagdinig ng House Committee on Justice, sinabi ni Chairperson Luistro na seryosong mga paratang ang kinakaharap ng Vice Presidente. Sinusuri na ng komite kung ang libu-libong pahina ng dokumento sa ika-3 at ika-4 na reklamo ay sapat o sufficient in substance para ituring na impeachable offenses. Ngayon naman ay hihimayin at susuriin natin ang mismong laman ng bawat reklamo, impeachment versus VP Duterte. Hindi ito biro, ito ay seryosong maparatang na nangangailangan ng seryosong pagsusuri.
The meeting of the Committee on Justice is hereby called to order. Since our today's meeting is a continuation of the yesterday's meeting, the calling of the roll is hereby dispensed with. The Chair shall address the Committee on Justice. Today is March 4. We reconvene the Committee on Justice on our third day of official deliberations on the impeachment complaints against Vice President Sara Duterte. Sa mga kasama natin dito at sa mga nanonood, our pace is deliberate because our duty is delicate. Hindi tayo narito para magmadali. Hindi rin tayo narito para magkubli. We are here to uphold the Constitution of the Republic of the Philippines calmly, carefully, courageously. When we began on March 2, 4 complaints were referred to this committee. The first was set aside pursuant to the 1-year bar rule. The second was withdrawn. Yesterday, we focused on the third impeachment complaint endorsed by Representative Laila De Lima. Yesterday, we discussed the substance of the third impeachment complaint. The allegations are not light matters. Misuse of confidential funds, bribery, grave threats, ill-gotten wealth, grossly disproportionate to lawful income, and acts allegedly undermining constitutional order. Representative Chel Jokno pointed us to disbursement documents bearing the Vice President's signature, raising questions of direct knowledge and accountability. Representative Joel Chua highlighted sworn affidavits referenced in the complaint, including testimony about procurement irregularities and the alleged handling of public funds. Meanwhile, Representative Rufus Rodriguez raised a constitutional question. Can a vice president be impeached for acts done while concurrently serving as Secretary of Education? The response from several members was clear. Public trust is indivisible. At that point, Representative Benny Abante gave us one of the most memorable moments of the hearing. He raised two hands and said, in essence, one hand may act separately from the other, but there is only one brain directing both hands. Dalawang kamay, isang utak, isang opisyal, isang pananagutan. You cannot divide accountability depending on which title is convenient. The Constitution speaks to the office, not the label. We also examined statements attributed to the Vice President that some characterized as conditional or not serious. Representative Bong Suntay even suggested that certain remarks were merely a joke or might fall under imagination. And that was when Representative Janice Degamo rose. She did not speak in anger. She spoke in memory. She reminded us that before the tragic killing of her husband, Governor Roel Degamo, there were threats, conditional at first, words, but words that became real. Her message was simple and powerful. Ang banta, lalo na mula sa mataas na opisyal, ay hindi biro. Threats from high office are never just imagination. They carry weight. They create fear. They can destabilize institutions. Yes, there were references to premonition on the first day and to imagination yesterday. At one point, an example involving a public figure seen in a mall was offered to illustrate the harmlessness of imagination. I will not dwell on that illustration. I will simply say this. This committee is not a forum of fantasy. Hindi ito sinihan. Hindi ito komedya. Ito ay pagdinig sa pananagutan. Let me say this clearly. Impeachment is not about premonition. It is not about imagination. It is about constitutional accountability. At this stage, we are not deciding guilt. Hindi pa ito hatol. The question before us is narrower but crucial. Are the allegations, if assumed true, for purposes of this stage, sufficient in substance to warrant further proceedings. If the accusations are speculative, we must dismiss them. If they are trivial, we must reject them. But if they raise serious constitutional questions about public funds, abuse of authority, and violations of public trust, then we must not close the door prematurely. So today, we turn to the fourth impeachment complaint, endorsed by Representative Benny Abante and D.S. Paulo Ortega. Some allegations may overlap with the third impeachment complaint. Others may reinforce it. Our task remains the same. Determine whether it meets the constitutional threshold of sufficiency in substance. So we ask, is the fourth impeachment complaint consisting of 7 grounds or 7 articles sufficient in substance? Do the allegations rise to the level of impeachable offenses? Do these complaints meet the constitutional threshold to move forward? And importantly, are the allegations credible enough to justify moving forward with the process? Iyan ang tungkulin natin ngayon. And by the end of our deliberations today, it is my hope that this committee will consider all the arguments from day 1 until today, from March 2 until March 4, and be prepared to vote on the sufficiency in substance of both the third and the fourth impeachment complaints. This is not about personalities. This is not about political convenience. Hindi ito laban ng kampo. Ito ay usapin ng konstitusyon. History will not ask whether this was comfortable. History will ask whether we were faithful to our oath. Kung sapat ang reklamo para umusad ang proseso, dapat natin itong ituloy. If the constitutional threshold is met, we should not be afraid to let the constitutional process move forward. Now, let us proceed, calm but firm, fair but fearless. Maraming salamat po. Before we proceed to the determination of sufficiency in substance of the fourth impeachment complaint, that is Cabrera impeachment complaint endorsed by the Honorable Abante and Honorable Ortega, we recognize the Honorable Bel Zamora.
Thank you, Madam Chair. This is for the information of everyone. We are discussing or deliberating on the sufficiency and substance of the fourth impeachment complaint. As such, I remind you of Rule 3, Section 5, Determination of Sufficiency and Substance. It states here that the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. What we are looking for, Madam Chair and our dear members and colleagues, we are looking for overt acts of the respondent that will show the nexus with the impeachable offenses as stated in the Constitution. Kailangan po natin makita o maipakita na ang impeachment complaint ay may overt acts o yung mga ginawa mismo ng respondent. At ito ay may connection o mangangahulugan na ginawa niya ang mga impeachable offenses sa Constitution. Yun lang po, Madam Chair. Thank you.
Before we proceed, we acknowledge the presence of the Honorable Arnan Panaligan from the 1st District of Oriental Mindoro. At this juncture, we open the determination of sufficiency in substance of the 4th impeachment complaint. To begin with, we recognize the endorsers of the 4th impeachment complaint, the Honorable Benny Abante and the Honorable Paulo Ortega, to make their manifestation with respect to their position on its sufficiency in substance.
Madam Chair, may I be allowed to please give my opening
You may
remarks?
proceed, Honorable Abante.
Madam Chair, distinguished colleagues, at mga kababayan po na nanonood ngayon sa ating live streaming, the Constitution of the Republic of the Philippines begins with a simple but powerful principle. Ito'y inuulit-ulit po natin to. Public office is a public trust. Na gusto ko nang dagdagan na hindi lang po ito public trust, kundi isang sacred trust. Sapagkat hindi natin maikakaila na ito po ibigay ng Panginoon sa atin. Hindi ito yung slogan. Hindi ito dekorasyon sa ating mga dokumento. Ito ang pundasyon ng ating demokrasya. In a democracy, leaders are accountable to the people. In a democracy, no official, no matter how powerful, is above the Constitution. And that is precisely why the Constitution gave Congress the power of impeachment. Because without accountability, democracy becomes something else. Without accountability, a republic begins to resemble a kingdom, where those in power answer to no one. We are not a dictatorship, Madam Chair. We are a democracy where we believe that we must be governed, where power answer to no one. We are not a dictatorship. Representatives, Madam Chair, may ask the most serious question that can be asked of a public official. Are you still worthy of the trust given to you by the Filipino people? That is the question before us today. Let me be very clear. This proceeding is not about personalities. It is not about political factions. And it is certainly not about the political ambitions of someone who will run 2 years from now. It is about her responsibilities to the nation because of the office she occupies today, Madam Chair. It is about whether the serious allegations contained in this complaint deserve the full and sober examination that the Constitution requires. The complaint endorsed before this committee presents several grounds for impeachment. Let me explain them in the simplest terms possible so that every Filipino listening can understand what is at stake. Dahil kailangan malaman ng ating mga kababayan na hindi biro ang mga akusasyon laban sa Vice Presidente. Unang-una, the issue of transparency and unexplained wealth. Our Constitution requires public officials to disclose their assets through their statements of asset, liabilities, and net worth, what we call as SALN. Now, why is this important? Because the Filipino people deserve to know that those who serve them are not secretly enriching themselves. If a public official earns a certain salary, but their wealth grows far beyond what the salary could reasonably explain, then the people have the right to ask questions. This complaint alleges that certain bank accounts, property transactions, and cash holdings were omitted or understated in the Vice President's SALN. It further raises the possibility that her accumulated wealth may be disproportionate to her legitimate income. Now, if these allegations are true, Madam Chair and my colleagues, that is not a mere clerical error. Hindi po ito biro. This is not a joke. That is what the Constitution calls culpable violation, a willful disregard of the duty of transparency. Pangalawa, the alleged misuse of public funds. The complaint cites findings from the Commission on Audit regarding the use of confidential funds under the Office of the Vice President and the Department of Education. Let us put the numbers in perspective, Madam Chair. More than 612 million pesos in confidential funds were placed under the authority of the Vice President across his offices. And one particular transaction has raised serious questions. 125 million pesos allegedly encashed and liquidated within just 11 days in December of 2022. 11 days, Madam Chair. In ordinary life, if someone withdrew that much money and claimed it was all spent in just a few days without clear receipts, without verifiable pays, people would naturally ask, saan po napunta ang pera? Oho. According to the complaint, some liquidation documents contain defective receipts, unverifiable pays, and irregular documentation. These are not small accounting errors, Madam Chair. Hindi po ito biro. Again, this is not a joke. When public funds are involved, every peso belongs to the Filipino people, and when hundreds of millions are spent without clear accountability, the public has the right to demand answers. Madam Chair, that is not free money. That is not a money coming from our own personal pockets. That is the money of the Filipino people. Di ba? The public money, akin nabanggit kahapon, is also a public trust. Kaya nga ang pangatlo, betrayal of public trust. This is one of the broadest grounds for impeachment in our Constitution. It refers to conduct that may not always fit nearly into criminal statutes, but nonetheless shows gross faithlessness to the public trust. And one allegation in this complaint is deeply troubling, Madam Chair and my dear colleagues. The Vice President publicly admitted that she had spoken to someone about killing the President, the First Lady, and the Speaker should something happen to her. Later, it was said that this merely was a joke. But let us be honest, threatening the life of the head of a state is not something that can be brushed aside as humor, particularly if this was even stated by the second holder of the authority of the land. Hindi po ito biro. This is not a joke. This is not what a wife can say to the husband, papatayin kita sa loob ng kwarto. Madam Chair, when the second highest official in the land speaks of assassination, even conditionally, as said by Congresswoman Digamo, it shakes the foundation of public trust because leadership carries weight. Words from high office carry consequences. Tanungin natin ng ating mga kababayan, if you had a neighbor who worked as an employee in a government office, and your neighbor posted a video saying he was planning to kill you, hahayaan mo lang ba? Or would you not want to report that person to his superiors and have him held accountable for his actions? Once again, gusto kong sabihin, hindi po ito biro at hindi po ito dapat magiging katawa-tawa sa lahat. This is not a joke. Number 4, allegations of corruption and bribery. The complaint also presents evidence suggesting that public funds may have been distributed through intermediaries, including testimony from individuals who claim to have transported large sums of cash. These are also allegations of payments connected to procurement decisions. Now, whether these claims, including testimony from individuals who claim to have transported sums of cash, these are also allegations of payments connected to procurement decisions. Now, claims, including testimony from individuals who claim to have transported sums of cash, these are is Congress in this country. It commands us to act. Now, some may ask, why impeachment? Why not leave this to the courts? The answer is simple, Madam Chair. Because impeachment is sui generis. It is unique. Oo. It stands alone. It is a unique constitutional process. Criminal courts determine guilt and punishment, but impeachment answers a different question. Is this official still fit to hold the trust of the Filipino people? That determination belongs to Congress. Ladies and gentlemen, belongs to Congress. Others will say that a previous impeachment complaint was dismissed. That is true. But that decision was based on a procedural technicality involving the one-year bar rule, not on the merits of the allegations. This complaint presents new evidence, including issues involving SALNs and unexplained wealth that have never been adjudicated. The Constitution demands that these allegations be examined. And finally, Madam Chair, my dear colleagues, some will say that this process is political. To that, I say, impeachment is indeed political in the sense that it is entrusted to elected representatives. But it is not partisan. It is political in the same way that democracy itself is political, Madam Chair, because it involves the people's right to hold their leaders accountable. Our duty here is simple. It is not to convict, it is not to condemn, but to determine whether these allegations deserve the full process that the Constitution provides. If we refuse even to examine them, we send a dangerous message that powerful officials can evade scrutiny simply by attacking the process. But if we proceed with fairness, sobriety, and respect for due process, we affirm something far more important than any political victory. We affirm that in the Philippines, the Constitution still reigns supreme and that no one, not even the Vice President, is above the law. Why? Because public office is both a public trust and a sacred trust. Uulitin ko po, Madam Chair, hindi po ito biro. This is not a joke. This is a solemn responsibility. And perhaps these words would also issue a warning to some of our colleagues that will make stupid analogies, Mr. Chair. I would not hesitate even to question that. Ito po, seryoso po ito. Gawin nating seryoso ang impeachment complaint na ito. Maraming salamat po, Madam Chair and my dear colleagues.
Thank you, Honorable Abante. May we know if the Honorable Ortega wishes to deliver a manifestation as well?
Yes, Madam Chair.
You may proceed.
I would join my co-endorser with a short manifestation. We endorse this complaint out of respect for our Constitution, and we carry this responsibility in the House of Representatives. This is not about declaring anyone guilty. It is our duty, and it is straightforward. For us to examine the facts and determine whether they are enough and there is enough basis to elevate it. If the evidence supports it, we elevate it. If it does not, we dismiss it. We owe the Filipino people a process that is fair, steady, and faithful to our mandate. Maraming salamat po.
Thank you. As pronounced during day one of our proceeding, we will be deliberating on a per ground basis, although we will be voting on the basis of the entirety of the complaint. We will now proceed to the deliberation per ground of the fourth impeachment complaint. Please allow the chair to read Article 1. Culpable violation of the Constitution, betrayal of public trust, and other high crimes, citing the following specific offenses: assassination plot, sedition, and subversion of constitutional order. We are now opening the floor for opinions, comments, and manifestations of the justice members.
Madam Chair.
The Honorable Franz Legaspi.
Madam Chair, just a short manifestation before I make a motion with regard to yesterday's discussions. Madam Chair, just like to manifest, similar to my manifestation yesterday with the Honorable Laila de Lima's own complaint, that we confine, or rather I address this to the committee members, that we confine our discussions to the facts recited. I would also like to manifest, based on my observations yesterday, that we uphold the respect, the dignity, and decorum that this committee deserves, that our chamber is expected to have. The nation is watching us, and I still ideally believe that as public officials or even law practitioners, that people will look up to our characters as examples to look up to, and how we will act today, how we will treat others and speak about others will ultimately shape the values of our people, especially to my fellow youth, in the years to come. With this, I wish to reiterate that we confine our manifestations to relevant statements, that we maintain our discussions to the facts recited, and have a fruitful, respectful, and dignified discussion ahead. With this, I move that the discussions yesterday's, as they are similar to the impeachment complaint today, be adopted as well for the Cabrera impeachment complaint, as the grounds in both complaints are very similar. Thank you, Madam Chair.
There is a motion to adopt the discussion yesterday on the sufficiency in substance of the third impeachment complaint. In our today's deliberation, in the sufficiency in substance of the fourth impeachment complaint with respect to similar grounds appearing in the two impeachment complaints. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is hereby approved. The discussions yesterday in the sufficiency in substance of the third impeachment complaint is adopted for the purpose of the determination of sufficiency in substance of the fourth impeachment complaint. May we know if there are Justice members who wish to comment or manifest on the first ground.
Madam Chair,
The Honorable Zamora.
let me just point out the specific paragraphs in the fourth impeachment complaint that refer to the impeachable offense charged. We find the acts under paragraphs 85 to 111, and these are all about the assassination plot. For the record, Madam Chair, thank you very much.
Before we proceed, we would like to acknowledge the presence of the Honorable Deputy Speaker Jefferson Conghun, the Honorable Deputy Minority Leader Jesus Manuel Bong Suntay, the Honorable Deputy Majority Leader Eliza Micaela Mica M. Gonzalez, the Honorable Deputy Minority Leader Stephen James T. Tan, the Honorable Congressman Jose Joboy S. Aquino II from the Lone District of the City of Butuan. We likewise acknowledge the Honorable Deputy Majority Leader Vincenzo Renato Luigi R. Villafuerte. We acknowledge as well the Honorable Deputy Minority Leader Reynolds Michael T. Tan. We acknowledge as well the Honorable Congressman Robert Nazal from BH Party List. We acknowledge also the Honorable Deputy Majority Leader Maria Alana Samantha T. Santos. We acknowledge as well the Honorable Congressman Vincenzo Renato Luigi Villafuerte, acknowledged already. We also acknowledge the Honorable Deputy Majority Leader Hill Kabarangay A. Acosta Jr. And finally, we acknowledge the presence of the Honorable Terry L. Ridon from the VPSARA party list. We acknowledge also the Honorable Deputy Speaker Yasser Alonto Balindong. And finally, we acknowledge the presence of Senior Deputy Minority Leader, the Honorable Laila De Lima. We are now opening the floor for comments, further comments and manifestations of the justice members with respect to the first ground of impeachment of the fourth impeachment complaint.
Madam Chair,
The Honorable Joboy Aquino.
I'd like to make a manifestation, Madam Chair, in regards to the first question. Does the first ground of impeachment of the fourth impeachment complaint contain a recital of facts constituting the offenses charged and demonstrative of the jurisdiction of the Committee on Justice? Madam Chair, I do believe the answer is yes, that the first ground contains a recital of facts constituting culpable violation of the Constitution, betrayal of public trust, and other crimes when VP Duterte admitted to contracting an assassin to kill the President, First Lady, and the former Speaker of the House of Representatives. Second, what are the recital facts of that constitute culpable violation of the Constitution, betrayal of public trust, and other high crimes? The complaint contains an allegation that VP Duterte, during a live press conference which was showed yesterday, Madam Chair, publicly declared that she had already asked a person to take revenge, and that if I get killed, patayin mo si BBM, si Liza Araneta, at si former Speaker Martin Romualdez. No joke and no joke. Thank you, Madam Chair.
Thank you, Honorable Joboy Aquino. Any other member who wishes to manifest on the first ground? If there are no other
Madam Chair.
members, the Honorable Suntay.
Thank you very much, Madam Chair. Kagaya ho ng aking binanggit kahapon, dito naman sa pang-apat na impeachment complaint, ang pangunahing allegation ng complaint ay nagsasaad, respondent publicly declared during a live broadcast press conference that she has arranged for a person to kill President Marcos Jr., the First Lady, and the former Speaker, Speaker Martin Romualdez, if she is killed. Ito ang ginawang basihan ng Article 1 para sabihing may culpable violation of the Constitution, betrayal of public trust, at other high crimes. Pero kapag sinuri ito sa ilalim ng Rule 3, Section 5 ng Rules of Procedures ng impeachment proceeding, may malinaw na problema sa sufficiency in substance. Ang requirement ng rule ay may recital of facts constituting the offense charge. Hindi sapat ang statement na controversial or politically shocking. Sa complaint na ito, ang allegation ay speech lamang. Walang alegasyon na may actual hitman na kinuha. Walang maipakitang may agreement nga o conspiracy na ipatupad dito. Wala rin naipakitang may payment o arrangement na ginawa in order to facilitate such statements. Wala rin maipakitang weapon procurement o alleged overt act. Sa ilalim ng constitutional law, malinaw ang doctrine na kahit incendiary, inflaming, or shocking ang speech, ito ay protected under the freedom of speech. Naipailalim to sa Brandenburg versus Ayo na sinabi ng korte that the speech can only be punished if it is directed to inciting or producing imminent lawless action and likely to incite or produce such action. Ang parehong principle ay kinilala sa Philippine jurisprudence tulad ng Salonga versus Cruz Paño kung saan sinabi ng Supreme Court na kahit radical o disturbing a statement ay hindi punishable kung walang imminent and lawful action. Sa madaling salita, kahit pa matapang, galit, exaggerated ang political rhetoric, hindi automatic na ito ay krimen. Ang complaint ay umaasa sa interpretasyon ng statement, hindi sa factual acts constituting treason, sedition, or conspiracy. There is a Latin maxim, conclusion non probat factum. Ang conclusion ay hindi proof ng fact. Thank you.
The Honorable SDML Noy Defensor.
That's wrong, Madam Chair. We are discussing on the sufficiency and substance and the irrelevant, illogical statements made in defense has no point because this is a direct threat to the life of the sovereign. And the allegation that the Vice President has contracted an assassin who is prepared to kill the President, whether or not there is a condition, as alleged in both complaints, I have seen the evidence and I have seen all the supporting documents, and this allegation is trial ready. Madam Chair, I move that we proceed to the next allegation.
Madam Chair.
Madam,
The Honorable, is that a motion, Honorable Defensor?
Yes, it's a motion to proceed to the next allegation.
I object, Madam Chair.
Second.
There is
Let us
a
give
motion.
chance. Let us give a chance to everyone to speak on each ground. And my good friend, and whom I respect so much, should be minded to withdraw that because precisely there are others who wish to speak. And we cannot stifle any member of the Justice Committee. And our chairman has always allowed everybody to speak until everybody has spoken in this committee. So we appeal to my good friend to withdraw that so that we can
Only
proceed.
because the Honorable Rufus Rodriguez has requested me to withdraw. I would gracefully withdraw my motion, Madam Chairman.
That is a statesman. You see, Mr. Chairman, our deputy is a statesman. So
Just
thank
for the
you.
record, the motion to proceed to the next ground has been formally withdrawn.
Thank you, Madam Chair.
All the manifestations of the justice members are duly noted. At this juncture, we recognize the Honorable Nazal and then Honorable Chua
Thank you. About me.
and then Honorable Rodriguez.
Third, that is fine.
Good morning, everyone. Thank you, Madam Chair. Consistent with the constitutional threshold articulated under Article 11 and the ultimate facts rule applied during the Pbbm proceedings last February 4, 2026, I respectfully submit that Article 1 of the fourth complaint fails the test of sufficiency in substance. The allegations rely principally on public statements characterized as an admission of contracting an assassin. However, even assuming hypothetical admission of the pleaded facts, the complaint does not set forth the essential elements of an indictable offense. There is no identification of an alleged assassin, no pleaded meeting of minds, no overt act towards execution, no defined consideration, and no operational step taken beyond speech. Conspiracy requires implementation elements. Sedition requires overt acts. Culpable violation requires a specific, willful breach of a constitutional duty. None are pleaded with particularity. General invocations of a constitutional order and oath-taking cannot substitute for a clearly identified constitutional provision willfully violated. Under the standard consistently applied in the PBBM proceedings, rhetoric, however alarming, does not become an impeachable offense absent ultimate facts establishing execution. Accordingly, Article 1 rests on inference and conclusion rather than pleaded ultimate facts and is insufficient in substance. I so manifest. Thank you, Madam Chair.
Thank you. Next is the Honorable Chua.
Thank you, Madam Chair. Madam Chair, mukhang nalilito po yung mga kasama natin. Wala po tayo dito para determine yung criminal aspect ng complaint. Nandito po tayo para tignan natin kung pag binasa po natin itong facts, ito po ba papasok as impeachable offense? Now, let me clarify this. Ito pong Article 1 makikita po natin sa paragraph 83 pababa. At dito po, sa paragraph 85, dito po, clearly and expressly, binanggit po dito yung kataga na binanggit po ng ating Vice Presidente. At ano po to? Already as a person to take revenge and that if I get killed, patayin mo si BBM, si Lisa Araneta, at si Martin Romualdez. No joke, no joke. Now, paano po ito papasok bilang impeachable offense? Sabi po dito sa same impeachment complaint, sabi po dito, makikita natin to sa paragraph 91 to 93. Ano po to? Meron daw pong culpable violation ng Constitution. Now, ano po yung specific provision sa ating Constitution ang binayolate? So, makikita naman po natin to sa Article 7, Section 5. Dahil dito po, sa Article 7, Section 5, nakasaad po dito ng ating saligang batas, and I quote, Madam Chair, before they enter on the execution of their office, the President, the Vice President, or the Acting President shall take the following oath or affirmation. Ang second paragraph, ito po yung kanilang oath. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as President or Vice President or Acting President of the Philippines, preserve and defend its Constitution, execute its law, do justice to every man, and consecrate myself to the service of the nation. defend its constitution and execute its laws. Definitely, yung pagbabanta po is not a form of executing its laws. And therefore, there is a clear violation and culpable violation of the Constitution. Second, sinabi po dito at binanggit din po dito sa complaint, betrayal of public trust. At dito po defined under paragraph 94, the Supreme Court has defined betrayal of public trust as a catch-all ground encompassing acts that constitute gross faithlessness against public trust, tyrannical abuse of power, inexcusable negligence of duty, favoritism, and gross exercise of discretionary power to the prejudice of the public interest. Gross faithlessness, pagtataksil sa tiwala ng publiko. Definitely, yung pagbabanta po sa ating Papangulo, sa First Lady, at sa ating Speaker, ay maliwanag na pagtataksil. Dahil itong tao po, yung Pangulo po natin, ay pinagkatiwalaan at hinalal para mamuno po sa ating bansa. We have to look at the surface. Hindi ko po sinasabi na guilty na. Dahil yung guilty or not, yung trial po yan sa Senado. Ang nandito lamang po ay by mere narration of facts, sa pagbabasa lamang po ba neto, meron po bang grounds na na-violate? I submit, Madam Chair.
Thank you, Honorable Chua. Before we proceed, we acknowledge the presence of the Honorable Congressman Jose Manuel Tadeo Chel Jokno from Akbayan Party List. We acknowledge as well our Deputy Speaker, Honorable Raymond Democrito C. Mendoza. And finally, we welcome and acknowledge our Senior Deputy Speaker, the Honorable Ferdinand L. Hernandez, of course, from the 2nd District of South Cotabato. Thank you for coming to all the Kongs. Now we proceed. We acknowledge the Honorable Rodriguez.
Thank you, Madam Chair. Article 1 is based on three grounds for impeachment. First is the culpable violation of the Constitution. Second, betrayal of public trust. And third, other high crimes. To support these three grounds for impeachment, as found in our Constitution, it has three acts that are alleged to support these three, and which are assassination plot, sedition, and subversion. Let us go first to subversion, not as a crime itself, but as a support to the three, either of the three. And so, subversion, Madam Chair, was precisely made illegal in 1937 under Republic Act 1700. However, subversion, like in this case, the state subversion of constitutional order, subversion, Republic Act 1700, was repealed precisely in 1992 during democratic times. In 1992, Republic Act 7636 removes subversion. It cannot be a crime nor a support now to the three grounds that we have. Completely repealed in 1992 the subversion aspect of an act of a Filipino. Then we have sedition, Madam Chair. Sedition is an act of publicly uprising and tumultuously engaging in acts to really remove the established government and officials. So it cannot be because Sara Duterte did not publicly rise with arms to be able to remove the present government. Probably what they want to say is inciting to sedition. Because sedition itself is governed by our Article 139 of the Revised Penal Code, the rising publicly and tumultuously. If you go to Article 142, this will be inciting to sedition, but there is also no recital of facts that the Vice President made speeches or made publications to say, let us remove the present administration. Nothing. In fact, yesterday, if you see the video, she was just present. When her father spoke. Second, when Kibolo had a mass at a gathering, but she did not speak there. So therefore, against the present government. So these two are out, definitely out. So version of constitutional order is no basis to say there is violation of the Constitution, nor sedition, or even inciting to sedition. So we now go to assassination plot. Here we go. This is what is cited in the first paragraph on factual allegations is under the page 28, paragraph 85. Ito na. Already asked a person to take revenge and that if I get killed, patayin mo si BBM, Lisa Raneta, at si Martin Romualdez. No joke. Now, we have to distinguish, Madam Chair, between conditional threat and threat with a condition. This is defined by the Supreme Court. What is a conditional threat and what is threat with a condition? Example of a second one. Threat with a condition. I will kill you if you give me 1 million pesos. That is a threat with a condition. There's still liability. However, conditional threat, like I'll kill you if I am killed, that is a threat from the grave, so-called. Even, Madam Chair, even the late presidential legal advisor, the late Juan Ponce Enrile, I saw him in an interview. He said there is no crime because it is conditional. The entire, statement about killing somebody only arises if you are dead, and both of them are very much alive. However, this is now the situation, Mr. Madam Chair. The one who said it is the Vice President. The persons where the conditional threat is being mentioned is the President, the First Lady, and the Speaker. And so this committee will have to therefore decide whether that reaches the sufficiency of form and substance. Thank you, Madam Chair.
Madam Chair.
The Honorable Zamora.
Madam Chair, I'd like to make another manifestation regarding Article 1. Article 1 of the fourth impeachment complaint. I was part of the prosecution team in the last impeachment, and I handled this. And we saw the evidence of the NBI. In fact, for the information of everyone, this went to the NBI. The NBI filed a case, and they have the evidence. Now, that threats were conditional, is inconsequential. We heard what the Honorable Janice Degamo said yesterday, and I believe that, we were all touched and maybe disturbed by what she said yesterday. She said that their family received threats, conditional at the start, but in the end, the threats became real and her husband was murdered. The video that we are talking about was viewed by everyone, including international media, international persons. This happened on the 23rd of November, 2024, early morning. And we all saw how the Vice President hurled expletives and publicly admitted that she had set into motion a clear plot to assassinate the President, the First Lady, and the former Speaker of the House. These acts, Madam Chair, are stated, as I said earlier, in paragraphs 85 to 111 of the impeachment complaint. It is clear that the overt acts that we are looking for are in the impeachment complaint. The video that we are all talking about was mentioned in the annexes, or was it? Yes, it was mentioned in the annexes of the complaint. And for everyone's information, this is what we call res ipsa loquitur, or the thing speaks for itself. Everyone heard what the Vice President said, and again, these are mentioned in the impeachment complaint. So we do not go into the elements of the different crimes of the revised penal code, but the mere act, Madam Chair, that she said these words and that she contracted an assassin is impeachable in itself. That's all, Madam Chair. Thank you very much.
Thank you. Any other member who wishes to manifest?
Madam Chair, can I be allowed to speak?
This will be your winding up as well, the Honorable Abante.
Yes.
After this, we will be proceeding to the second round.
Upon
The Honorable
he-
Abante is recognized.
Upon hearing the statement of Congressman Rufus, medyo umiikot po yung aking isipan tungkol dito sapagkat nakalagay naman sa impeachment complaint natin yung bang grossly inconsistent with the dignity of her office. Now, the question is, proper dignity ba yung statement ni Vice President Sara when it comes to assassination threat? Hindi lamang assassination threat, Madam Chair, assassination plot, sapagkat meron na po siyang hinire na assassin. Sinabi niya sinabi niya, hindi joke yan. Pangalawa, yung po sinasabi nating gross exercise of discretionary powers. Yung pa'y kasama pa sa tinatawag na discretionary powers ng Vice President to threaten the President. Hindi na pinag-uusapan dito yung sedition. Saka yung subversion. Ang pinag-uusapan po dito, yung dignity ng office ng Vice President. Yung discretion powers ng Vice President. Yung po ba ang tinatawag natin? Dapat ba na ito ay gawin nating baliwala? Madam Chair? So while the VP may claim her remarks were not serious, a high-ranking official threatening the life of the head of a state is a high crime and a threat to national stability. Yun po.
Thank you. Now we proceed to Article 2 of the fourth impeachment complaint. Please allow the chair to read. Betrayal of public trust and graft and corruption. Among the offenses cited are misuse and malversation of confidential funds, violation of Joint Memorandum Circular number 2015-01, COA findings, and falsification of documents. Now we elicit the comment and manifestation of the justice members.
Madam Chair,
The Honorable Rodriguez.
Bongsunta is not here, so I just go ahead because he would have been first always. Madam Chair, on Article 2, it is betrayal of public trust and graft and corruption. I would just like to take exception in accordance with what I stated yesterday. Page 34 includes the DepEd. And as I have stated, and I remind again members of the Committee on Justice, that we have no jurisdiction over actuations of the former Secretary of the Department of Education. So, page 934, we say that the statement of corruption by grossly abusing discretionary authority over confidential funds appropriated to the OVP, that's fine. But the statement that DepEd is totally out of the jurisdiction of this committee, the actuations of the former secretary. Then on page, Madam Chair, on page 36, once again, 1223.3 paragraph, 125 million in DepEd confidential funds in the late 2022-2023. Again, DepEd, we cannot have jurisdiction over DepEd. The case of Duterte versus House of Representatives clearly state that the impeachable offenses must relate to the acts of the position and the office where the person is sought to be impeached. And we're not going to impeach the secretary of a department here, but there is an allegation against her as the vice president. So that is page 36. And then on page 38, we have here 129 paragraph. It says a random sampling of receipts and acknowledgement receipts submitted by the OBP and DepEd revealed numerous defects. So once again, the statement of DepEd, the statement about DepEd is that it is beyond our jurisdiction. And then also 132, several receipts, OVP and DepEd should not be included. Now, on page 39, there is this allegation of physical distribution and third-party deliveries, use of DepEd vehicles and personnel. Again, this is about DepEd. It could not be part of the investigation on the allegations of the impeachment. And so, Madam Chair, those are my observation on Article 2. Thank you very much.
Madam Chair.
Meanwhile, the Chair wishes to remind the Justice members, while we value the significance of all your arguments, we resolve already to adopt the discussion we had yesterday in the determination of sufficiency in substance of the third impeachment complaint for the purpose of our deliberation on the sufficiency in substance of the fourth impeachment complaint. We therefore encourage the members to raise new matters. Members who wish to manifest, the Honorable Chua, and then
Madam Chair.
Honorable Tino,
Madam Chair.
Honorable Joboy Aquino, and Honorable Chel Jokno,
Madam Chair.
and Honorable Abante,
Madam Chair.
and Honorable Nazal. Honorable Chua first.
Thank you, Madam Chair. Madam Chair, as already manifested yesterday, I stand with my position that the Vice President, we should not distinguish between her position as Secretary of DepEd and Vice President by, again, citing the constitutional provision that under the Constitution, the Vice President may be appointed as member of the Cabinet and such appointment requires no confirmation. So meaning to say that the appointment of the Vice President as Secretary of DepEd is concurrent position. Hindi po siya ma-appoint doon if she were not the Vice President. And secondly, siya nga lang po ang nag-iisang Vice President, siya nga lang po nag-iisang Cabinet Secretary na hindi na kailangan ng confirmation. Precisely dahil siya po ay Vice President. And thirdly, in addition to those statements and for the information of the body, the Vice President as Secretary of the DepEd is not receiving any allowance or emolument as Secretary of DepEd. Therefore, and it is very obvious na kaya po siya nandoon, again, because of her position as Vice President. Having said that, Madam Chair, I would like also to point out that from the perusal of the second argument, sabi po dito, ito pong second ground anchored on the allegation that the Vice President has committed betrayal of public trust and graft and corruption. Now, paano po pumasok ito? Kung babasahin po natin doon sa paragraph 1, 2, 3, sabi po dito, on 20 December 2022, Land Bank check number 2244027 in the amount of 125 million was issued to the OBP and encash at the Land Bank Show Boulevard by SDO Gina Acosta. So dito po sa paragraph na to, makikita natin, wala pa pong participation ang ating Vice President. Now, ito pong paragraph 1, 2, 3, this should be read in relation to paragraph 1, 3, 4. Dito po sa Madriaga Affidavit, chain of custody. Dahil ito pong winidraw dito sa paragraph 1, 2, 3 na 125 million na in-encash na sinasabi na nilagay po sa mga multiple bags na nakalagay sa paragraph 125 na binigay po kay Dante La Chica ay binigay po kay Madriaga. At dito naman po si Madriaga, sinasabi po niya na ito daw duffel bag, 4 na duffel bag na kinuha niya ng cash sa Ultra Pasig City noong December 20, 2022. Take note of the date, Madam Chair. Ibig sabihin, ito rin yung araw kung kailan in-encash yung 125 million. Siya daw ay nag-deliver netong 4 na duffel bag sa various recipient including a mayor in Laguna, an office in Timog, and a vehicle left at the Ombudsman parking compound for retrieval. At this point, wala pa rin pong participation ang ating Vice President. Now, paano po napunta dito? Paano po ito naging impeachable offense? Makikita po natin yan sa paragraph 150. Kasi dito po sa paragraph 150, nakalagay po dito, the OBP SDO's testimony that they were instructed to turn over cash to intermediaries, which is Nolasco to Madriaga, at the direction of respondent Sara Duterte supports direct liability. So dito po pumapasok yung participation ng respondent. Kaya po, dito po pumapasok yung grounds which is grave, which is betrayal of public trust and graft and corruption. So with that, pagbabasahin lamang po natin yung facts, makikita po natin na may sufficient in substance. That's all, Madam Chair.
We just want to share to the justice members that the Madriaga affidavit referred to by the Honorable Chua is part of the attachments, I think, of both the third and the fourth impeachment complaint. That's for the guidance of the justice members. Before we proceed, we would like to acknowledge the presence of the Honorable Zia Alonto Adjong from the 1st District of Lanao del Sur. We also acknowledge the presence of Deputy Majority Leader Crispin Diego D. Remulla. And we acknowledge as well the presence of Deputy Speaker David J.J.C. Suarez. To proceed, we would like to recognize the Honorable Joboy Aquino.
Thank you, Madam Chair. Earlier, Madam Chair, we've heard that from our good friend, Congressman Rufus Rodriguez, that we cannot, as Education Secretary, we cannot impeach her because they covered. But all I want to say, Madam Chair, is it is the same person also that is being accused of a crime to commit murder. No? What I'm trying to say, isang tao lang to. Pero yung ginagawa niya sa OVP, ginagawa niya rin sa DepEd. That's all. Simple lang yan, Madam Chair. Thank you.
Thank you, Madam Chair. Pag binasa po nyo itong mga nakalagay sa Article 5 regarding unexplained wealth, SALN violations, bank records, and financial forensics, nakalagay lahat sila based on assumptions in preliminary documentary leads, hindi po solid proof. It keeps saying that a forensic review will uncover unexplained assets, but as of now, wala naman napakita yung complaint. Wala man lang attachments na kahit ano to prove itong sinasabi na unexplained wealth. First, the complaint talks about supposed discrepancies in the SALNs, but differences in reporting do not automatically mean someone was dishonest. Hindi po ako abogado, but I'm an economist. Bago po ako naging congressman, alam naman po natin na property values change. Assets can be bought or sold at different times. To immediately label this as pattern of concealment without clear proof of intent is unfair and speculative at best, Madam Chair. Second, kailangan daw po ng forensic financial review to reconcile declared income and assets sa SALN. Identify unexplained inflows or transfers, and trace the disposition of public funds alleged to have been diverted. Hindi ba dapat po trabaho ito ng complainant na mapakita ng ebidensya sa reklamo niya para maging sufficient in substance? Third, the complaint points to large cash disbursements from confidential funds and say these correlate with certain financial movements. But yung mismong complaint admits in paragraph 237 that correlation is not conclusive. Suspicion based only on timing does not prove personal gain. So, mag-i-impeach po tayo ng Vice President na binoto ng 32 million na tao na Pilipino dahil lang sa suspetsa. Third, the mention of intermediaries, third-party accounts, corporations, or relatives is likewise made to sound suspicious. But many lawful transactions are done through representatives or business entities. These arrangements are common and legal. Dapat man lang may katibayan o pruweba na ginagamit ang mga ito para sa mga illegal na gawain. Wala naman pinakita na kahit anong dokumento sa complaint. Fourth, alam natin, Madam Chair, na ang bank secrecy is not absolute, pero hindi natin ito dapat ma-set aside based on unverified claims. Investigation should be based on real and credible evidence, not on fishing expeditions in the hope of finding something. Most importantly, ang impeachment ay isang seryosong constitutional process. Kaya dapat, it should not be based on guesses or on what someone thinks might be discovered later. The burden is on the accusers to prove actual unexplained wealth. The Vice President should not be expected to disprove mere suspicions. At the end of the day, Madam Chair, Article 5 is asking people to assume guilt based on what might be found later, not on what has clearly been proven now. Allegations and suspicions are not the same as evidence. Thank you, Madam Chair.
Next is the Honorable Rodriguez.
Yes, thank you, Madam Chair. With due respect to our new Deputy Minority Leader, she tried to explain Article 5, which has zero recital of facts, unexplained wealth, SALN violation, back records, and financial forensics, by going to the statement of facts. And that's just right, that we can cite that. However, what does paragraph 76 state? Are these recital of facts? I will read, Madam Chair, and it is for all of us to determine whether this is a recital of ultimate facts constituting the offense. It says here, public records and investigative leads indicate existence of bank accounts. What are these public records? What are these investigative leads? You know, Madam Chair, you can see here, the fourth impeachment complaint is really a big volume of annexes. There is no annex on this particular, what are the public records? Nothing. See? What are the investigative leads? There has to be statements. You cannot just say, for example, that there is draft and corruption without also stating the ultimate facts constituting that. You cannot just say, malversation. You cannot do that. There has to be a statement of facts. Now, you say public records. What are these public records? To give us an indication that there's a crime has been committed, that a impeachable offense has been committed. Nothing. And then it says other financial movements. Very vague. Other financial movements. There are a lot of financial movements. In the stock exchange, in the trade and commerce of people. So, what are these financial movements? And they say that are disproportionate to respondent Sara Duterte's lawful income and not fully reflected in her SALN. Which SALN? 2022? 2023? 24? 25? No statement here. It's a general blanket statement. These are not recital of facts. So therefore, paragraph 76 does not support Article 5. So once again, there is absolutely no, that's only insufficient, nothing, no substance in Article 4. Thank you, Madam Chair.
Madam Chair,
Honorable Ridon.
we'd like to, before indulging...
Before we proceed, may I just acknowledge first the Honorable Paulo Henry M. Marcoleta from Sagip Party List. Before we proceed.
Before indulging our good colleague, Congressman Rodriguez, on the public records that is actually looking for, I'd like to read for the record the articles of impeachment of the Corona impeachment process in which former Chief Justice Renato Corona was convicted, and SALN was one of its bases, no? It was a very general narration of the facts, and I think this should be the same standard because this has undertaken the entirety of the process of impeachment from the express route towards final conviction at the level of the Senate. So I will read it. Madam Chair, (2.4) Respondent is likewise suspected and accused of having ill-gotten wealth, acquiring assets of high values, and keeping bank accounts with huge deposits. It has been reported that respondent has, among others, a 300 square meter apartment in a posh Mega World property development at the Fort in Taguig. Has he reported this as he is constitutionally required under Article 11, Section 17 of the Constitution in his Statement of Assets and Liabilities and Net Worth, SALN? Is this acquisition sustained and duly supported by his income as a public official since his assumption as associate and subsequently Chief Justice? Has he complied with this duty of public disclosure? We are stating it for the record, Madam Chair, because this is the precise wording of the Corona impeachment articles of impeachment which had proceeded to the Senate and had resulted in a conviction, Madam Chair. So I think it is very clear that this is the process that we have to undertake, and what the endorsers would want to undertake during the process of full proceedings can be undertaken. It does not require what our colleague is actually asking today. It would be good had the annexes been there, but is actually not in fact required for full impeachment proceedings to proceed. But I think the crux of the matter is, what is the definition of unexplained wealth, Madam Chair? Because I think this is something that we would want to be able to talk about as well. Yung pong unexplained wealth, mga kaibigan, meron pong very specific definition yan sa atin pong mga batas. A public officer and employee acquires property during their incumbency. So if we are talking about the Vice President, from 2007, from her first year in public office to date. And second element is the amount of property is manifestly out of proportion to their official salary and other confirmed local income. And at this point, I will indulge our colleague about the public records on which this committee can actually take judicial notice of. So I will read to the record, Madam Chair, the totality of the net worth of the Vice President from 2008. 2008, filed December 31, 2008. Net worth, 18,493,617. SALN 2009, net worth, 18,281,000.
May we be clarified, Honorable Ridon, of the reference from which you are reading?
Well, we have the references of the SALNs themselves.
That is the
Madam
SALN
Chair.
of the Vice President?
And some of the public, available public information relating to the SALNs.
May we know specifically which document
Well,
is
I will
that?
present for the record the most recent SALN that had been released by the Ombudsman, Madam Chair. I think it is something that can be flashed on the screen. But I think what should be noted is the original SALN net worth, which was 18 million, Madam Chair. 18 million.
With the indulgence of the justice members, we will be flashing on screen the document which is the reference of the Honorable Ridon.
Yeah, but to have a starting point, Madam Chair, the original SALN 2008 is 18,493,617. It was filed December 31, 2008. So we will be flashing the SALNs for 2023 and 2024. May we request, Madam Chair, that the Secretary be directed to flash?
For the record, the SALN from which the Honorable Ridon is first referring to is the 2008 SALN, which provides for an 80 million net worth. And with the indulgence of the members, we will be flashing the 2023 and 2024 SALN.
Madam Chair, this is the 2023 SALN. We can proceed to see the totality, the net worth, Madam Chair. 2023, can we go down further, please? A little bit down. Ayan, net worth po. Net worth for 2023. 77,508,841 pesos. This is for 2023, Madam Chair. Can we flash 2024, Secretariat, please?
Kindly flash the 2024.
Can we
Scroll
go-
down first.
Okay, yeah,
please.
that's correct. For 2024, released by the Office of the Ombudsman, net worth of the Vice President is, can you put it a bit further, please? Up.
Down, please.
88,512,370.22. So we are submitting it for the record because these are public records which our colleague had actually asked for. And if we will base it from the original SALN at 2008 to the 2024 SALN, Madam Chair, it is an increase of more than, I think, 1,200%. So we leave it to the Justice Committee as to whether or not we would consider it.
There was an increase of 10
As a-
million pesos, Madam Chair.
Sorry?
From 77 million to...
No, the original
88.
SALN at 2008.
How
which
much
was
is the 2008 SALN?
18 million.
1.8. Is it 1.8 or 80?
1.8.
It's 1.8 million. Do you have a copy of the SALN also of 2008?
We will locate it, Madam Chair.
So, we're stating for the record, it was being shared to us by the Honorable Ridon that for 2008 SALN, the net worth is 1.8 million. And now we are shown by 2023 and 2024 SALN, which shows net worth of 77 million and 88 million respectively. Do you have any additional manifestation?
That is correct, Madam Chair. So we leave it to the House Committee on Justice to make a determination on whether the comparison between the original SALN at 2008 and the current SALN at 2024 constitutes unexplained wealth, which is essentially part of the impeachable offenses that we would want to proceed with at this point, Madam Chair.
Madam Chair,
The Honorable Rodriguez.
2 points. First point is that the impeachment proceedings in the Committee on Justice against Chief Justice Corona, this representation has attended since 2007, 4 impeachment complaints, which I have been a member of this committee since 2007. The first complaint was against the President, GMA. 2007, I was new, dismissed. Then we have Gutierrez, Residita, she resigned. And then we have Corona. On record, Madam Chair, precisely, this representation voted no to the Corona complaint. Because to me, there was no sufficiency of substance. And in the resolution of the House of Representatives, I voted no. In the Senate, it proceeded because the majority, of course, with the president at the time pushing for that, he was therefore impeached. In other words, the proceedings there are completely different now. I don't know that during the time they allowed it, but here our chairman is making sure that we follow the requirement of substance, that there should be sufficiency in form and substance, and there should be recital of facts. Well, in that particular case, I lost. I was against it. It proceeded. But I voted no. I did not want Chief Justice Corona to be impeached. Later on, it has come out that there have been lobbies with senators to impeach Corona, you see. So, therefore, that is what happened before. But now, Madam Chair, we are with you. You are presiding this very well. And we want to have the real recital of facts constituting the offense charge. And certainly, based on this, and based on the complaint, and based on the annexes, wala. Now, a new matter is injected by our friend, Congressman Ridon, stating about SALNs of 2023, 2024. Is that particular SALN, has that been authenticated by the Ombudsman? Do you have a copy of authentication of the Ombudsman?
Honorable Ridon.
I don't think that is required. It is public record, Madam Chair.
You know, there's no automatic authentication, public record, all the records. There has to be authentication. When you go to a proceeding like this, it's the Justice Committee of this country, of the House of Representatives.
Madam Chair.
You cannot just state that it's a public record. Now, where is it? Where is it? Is it found in the complaint? Because we are limited, Madam Chair, to the complaint and to the annexes. Here we are. We're limited with this. To inject something based on the statement, and there is no authentication that we have, there is no such thing as automatic authentication. In any proceeding, you have to authenticate.
No,
so
Madam-
therefore, there can be,
Madam Chair.
unless there is an authentication and the Ombudsman has already certified that, we cannot take cognizance of that particular injection of this new matter in the hearing. Thank you, Madam Chair.
Just to be clear,
Honorable De Lima first, and then Honorable
excuse me,
Po, and
Madam
then
Chair.
Honorable Ridon.
Authentication can be done at the evidentiary stage. No need for authentication at this point. The committee can subpoena, can request copies of those SALNs from the official custodian, the Office of the Ombudsman. So authentication at this point is not needed. Thank you.
I disagree, Madam Chair. May I be just one sentence? Our
Proceed.
verification. I will read now the verification. Verification of this. What does it say? In the verification of
Personal
the complaint.
knowledge or authentic records.
Yes, precisely. We have to have ultimate statement of facts, personal knowledge of the complainant, Attorney Cabrera, and then, of course, here we go. I will read now the verification of Attorney Cabrera. Aha.
I think it was just one
Allegations-
sentence, Madam Chair.
Let
This
us
is one
wait.
sentence.
Let us wait
This is my last
until
sentence.
he finishes with his
No, that's three
manifestation.
sentences already, Madam Chair.
My 3 sentences is considered as 1 sentence.
All right, Madam Chair.
The allegations, number 3, the allegations in the complaint are true and correct based on my personal knowledge or based on authentic documents. See? That's very clear. Nobody can debate with that. And if Congressman Ridon says this is authentic, that is his word. We have to get authentic documents signed and duly certified by the Office of the Ombudsman.
Yes.
Thank you, Madam Chair.
Honorable
That is
Rodriguez,
5 sentences, but considered
That was one paragraph already. The Honorable Ridon.
Madam Chair, it's a very basic question. That is an irrelevant response. You know why? Because firstly, I am not the complainant. I am not bound by the verification. Hindi ba? Why are you talking about authentic records? I am speaking as a House member and participating in House Committee on Justice. The point is not on point, Madam Chair. And my question is basically, are we being challenged that what is being presented is actually not the true representation of the SALN of the Vice President for 2023 and 2024? Kasi parang ganun yung dating. And more importantly, di na ba so ito? Nakita ho ng bayan, yung 88 million
Madam Chair.
na laman po ng SALN. So, think ko, that should not be considered,
Chair.
Madam Chair.
The Honorable Po, and then the Honorable Suntay, and then the Honorable Dilima.
Madam Chair, so we can move forward already. I just want to clarify for the body whether or not the Honorable Congressman Rufus Rodriguez is asking us to ignore the SALNs that were presented earlier. Is that what we're being asked?
That is precisely to answer. Can I answer, Madam Chair?
You're recognized,
You cannot
Honorable
inject
Rodriguez.
anything not found in the complaint, in the annex. Because then the requirement that Attorney Cabrera, is of personal knowledge and or authentic, that is very clear in all verifications. Authentic.
We go back to Honorable Po.
Well, then, to that point, I believe that we should move into merit so that that can be admitted as part of the evidence, no, in,
Madam
the,
Chair,
in this situation.
well, he's right to ignore it, but Madam Chair, just one last
Yes,
one.
you may
point.
proceed.
Well, he's right to ignore it, but firstly, he was challenging the availability of public records. So we were submitting the public records actually available. And secondly, I am not asking that it be made part of the complaint. This is being submitted for the consideration of the body that it is untrue that public records relating to SALN, unexplained wealth, do not currently exist. It exists. And we had been submitting it for the record, Madam Chair, irrespective of whatever documents that had not been submitted by this complaint. Madam Chair, I submit.
The Honorable Suntay.
Thank you, Madam Chair. Well, Congressman Ridon stated two facts. First, tama yung sinabi niya, he's not a complainant, but he's trying to introduce new documents which he wants us to consider. Second, the document he is trying to introduce is not to the knowledge of the complainant. So, we cannot consider it here because it's not part of the complaint.
The Honorable Dilima.
Thank you, Madam Chair. Nothing prevents this committee from directing the production of SALNs as essential documents in determining the facts of these proceedings. Impeachment is sui generis. We have all the plenary power or authority to do that, just to arrive at the correct conclusion, just to substantiate and establish the necessary and essential facts. That is my position, Madam Chair.
Just like any other manifestation of the justice members, the document presented by the Honorable Ridon forms part of his manifestation. And
Madam Chair.
therefore, all of your manifestations, including the documents which were shared, will become basis of the judgment of the justice members in determining the sufficiency in substance.
Madam
That
Chair.
might not be introduced as an evidence yet, but that might be introduced as part of the manifestation of the Honorable Ridon. The Honorable Padiernos.
Thank you, Madam Chair. So I'd just like to point out in our rules of procedure in impeachment proceedings, under Section 7, kasi pag-usapan po natin yung mga SALN and other documentary evidence. So it says here that the committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. So ibig sabihin po nun, again, at this stage, we're just merely looking at the recital of facts, whether it constitutes an impeachable offense. So I would just like to proceed with my manifestation. So Madam Chair, on Article 5, the committee's task is not to decide whether the respondent actually has unexplained wealth. The question is whether the complaint pleads a coherent theory of liability supported by alleged facts, which, if true, could amount to an impeachable offense. As pleaded, Article 5 alleges that public records and financial leads point to assets and financial movements inconsistent with lawful income and allegedly not fully reflected in SALNs, which, if assumed true, raises a serious accountability issue under the SALN regime and supports a theory of betrayal of public trust. Kaya lang po, meron po tayong case. I just wanted to also share with the committee the case of Salig, where the Supreme Court held that it cautions that errors in SALN do not automatically equate to dishonesty, absent intent and due process. Kasi na-mention din po kanina, it's unfair daw po na kung merong hindi na banggit sa SALN ay automatically liable na dapat yung impeachable officer. So those considerations are matters for later stages. Again, hindi po natin sinasabing guilty ang ating impeachable officer at this point in time. We are merely looking at sufficiency in substance, yung which later on pwede po mag-submit yung ating impeachable officer or respondent ng kanyang mga defenses. So at this stage, the pleaded allegation is that the omissions are material and linked to unexplained wealth indicators, which it would appear would be enough to cross the threshold of sufficiency in substance. Thank you, Madam Chair.
Madam Chair.
Thank you. Honorable Zamora.
Thank you, Madam Chair. 2 points. First, this is regarding the ultimate facts that must be alleged in a complaint. And this goes for all of the allegations in the impeachment complaint. Salita versus Honorable Magtalis, GR number 106429, June 13, 1994 states, a complaint only needs to state the ultimate facts constituting the plaintiff's cause or causes of action. Ultimate facts has been defined as those facts which the expected evidence will support. As stated by private respondent, the term does not refer to the details of probative matter or particulars of evidence by which these material elements are to be established. It refers to the facts which the evidence on the trial will prove and not the evidence which will be required to prove the existence of those facts. Second point, Madam Chair, we were discussing lengthily about the public documents, the SALN. Public documents follow the self-authentication rule. They do not need further authentication. They should be enough, and their existence as public documents is by itself their authentication. Thank you, Madam Chair.
Honorable De Lima, would you like to make manifestation?
That is exactly my point also, Madam Chair, about the
All right.
self-authentication rule relative to public documents. And SALNs are public documents. When we're able to get them, they are public documents. Thank you.
I think we have made an ample exchange of arguments in as far as SALN is concerned. But I wish to reiterate that while it is true that we cannot introduce evidence at this stage, those SALNs which were flashed by the Honorable Ridon forms part of his manifestation. And therefore, just like any other manifestation of the rest of the members of the Justice Committee, will serve as basis in our determination of the sufficiency in substance. Now we proceed to the next ground. Please allow the Chair to read. Article 6, Other High Crimes, Pattern of Abuse, Threats, Incitement, Interference with Civilian Supremacy. The offenses specifically cited includes admission plus capability equals grave threat, pattern of conduct demonstrates willful subversion, incitement and public official responsibility, institutional harm, and public confidence. We open the floor for deliberation on the second ground, on the sixth ground.
Madam Chair,
The Honorable Dilemma.
this is my observation with respect to the sixth ground, the Article 6. I think it will now be unnecessary for us to further tackle and treat this ground as an article. And that goes through with respect to the last article, Article 7. Because as I was reading it, it's actually just a sort of a discussion, a summation of the discussions, the earlier discussions on the 5 grounds. Other high pattern of abuse, threats, incitement, interference with civilian supremacy. They refer to the same set of facts and allegations. The same is true with respect to Article 7. Article 7 says, pattern of abuse, cumulative misconduct doctrine, remedies, prayer, and verification. So these discussions are not strictly and technically discussions of grounds or articles. It's just really a matter of style that the drafter of this pleading thought it best to also include this in the discussions, but they need not be discussed, considered, and treated as separate grounds or articles. So for me, since there have been sufficient discussion already about the first 5 grounds in relation to also to our discussions yesterday with respect to the third complaint, I think this is unnecessary to further deliberate on this, because it's clear to me they need not be considered as articles, but just a discussion, a summing up, a wrap up. So I move, Madam Chair, to dispense with the consideration or deliberation on both Articles 6 and 7 for the reasons that I stated. I so move.
Second.
Madam Chair, I second.
Before we act on the motion, let us put on record the manifestation of the Honorable Dilemma that the 6th and 7th ground are summation of the 5 prior grounds, and therefore the discussions that we had in the 5 prior grounds, including the discussions we had yesterday already with respect to similar grounds, support already the needed deliberation with respect to the 2 last ground, that is the 6th and the 7th ground. We state that to form part of the transcript of records of our deliberation today. So there is a motion to dispense with the deliberation of Article 6 and Article 7 for the purpose of the determination of sufficiency in substance of the 4th impeachment complaint. The same has been seconded. Is there any objection? Hearing none, the motion is hereby approved. The deliberation for the 6th and 7th ground are dispensed with. That concludes the deliberation for the determination of sufficiency in substance of the 4th impeachment complaint. Having said so, then the members are reminded to be ready to vote for the sufficiency in substance first of the 3rd impeachment complaint, followed by the 4th impeachment complaint.
Madam Chair.
Madam Chair,
Before we proceed, we recognize the Honorable Senior Deputy Speaker Ferdinand Hernandez.
Madam Chair, this is just a manifestation before we vote on the sufficiency in substance. At this juncture, it is important to clarify for the public what this vote means, and equally important, what it does not mean. Our vote on the sufficiency and substance of the impeachment complaint is not a determination of guilt or innocence on the part of the Vice President. We are not conducting a trial today, nor are we rendering a judgment on the allegations contained in the complaint. What the Constitution requires us at this stage is far more limited but nonetheless essential. The committee is merely determining whether the allegations, assuming them to be true for purposes of evaluation, are sufficient in substance to warrant the continuation of the impeachment process. If the complaint is found sufficient in substance, it does not mean the Vice President is guilty. What it means is simply that the process will move forward to the next stage, where hearings will be conducted, evidence will be presented, and the parties will be given full opportunity to be heard. After the proper hearings and evaluation of evidence, the House will then make appropriate determination, either to dismiss the complaint for lack of sufficient basis, or to elevate articles of impeachment to the Senate, where the Constitution mandates that the impeachment trial shall ultimately take place. To stress, our vote today is not a verdict of guilt, nor an act of condemnation. It is simply a decision on whether the constitutional process should move forward. The House is not an arena for trial by publicity, but an institution bound by due process, fairness, and the rule of law. Our duty today is simply to allow the process, as mandated by the Constitution, to take its proper course. In undertaking this duty, we assure the public that the process will be impartial, fair, and faithful to the Constitution, with full respect for the fundamental right to due process of all parties involved. In this way, we protect not only the rights of the respondent, but also the integrity of our democratic institution and the rule of law. Thank you, Madam Chair.
The Chair understands the difficult decision that the members are about to take. And with that, the Chair commends the courage, the disposition, the candor of the members who are present right now to exercise this constitutional duty.
Madam Chair, point of inquiry.
What's the point of inquiry of the Honorable Padiernos?
Madam Chair, before we vote, may we get the guidance of the chairperson as regards to the complaints, wherein if you have multiple grounds and you agree to only some of them?
Under the rules, we will be determining the sufficiency in substance on the basis of the entire impeachment complaint. What is being determined is the sufficiency in substance of the complaint and not the individual grounds. We adopted the deliberation that we had in the prior impeachment proceedings, that is by going over all the grounds, only to give a better and wider perspective to all the justice members to come up with their individual judgment. With that, if the members have no other matters to raise, we shall proceed to vote.
Madam Chair.
Madam Chair.
The Honorable Rodriguez.
In the Pbbm impeachment, we allow the Honorable Laila de Lima to also state that in one of the grounds, he concurs in one and then the other, she would not. Because for example, this representation, Madam Chair.
If I may interrupt the Honorable
Yes,
Rodriguez.
please. Yes.
The disparity as to the position of the Honorable De Lima with respect to the first and the second impeachment complaint, but not with respect to the individual grounds.
I have clarified, but can we put on the records, for example, if, for example, in the third complaint, which we are going to vote on, what will happen if 4 of the grounds for example, in my case, just to be able to state, 2 of the grounds, there is substance. 4 of the grounds, no jurisdiction, no substance. How will that be reflected, Madam
With
Chair?
all due respect, the Chair has stated already that the rule provides the determination of the sufficiency in substance with respect to the impeachment complaint and not to the individual grounds. Again, we deliberated per ground only to give a better perspective to the justice members in the determination of the sufficiency in substance. In other words, we will be voting on the entire impeachment complaint and not on the individual grounds. And we are not conceiving as well the situation where the members will be manifesting a different position with respect to a respective ground of the impeachment complaint. With that, we shall proceed to vote. The Chair is now ready to hear the motion on the sufficiency in substance of the third impeachment complaint, that is Father Sabalia et al. Impeachment complaint endorsed by the Honorable Congresswoman De Lima.
Madam Chair.
The Honorable Asidre is recognized.
Madam Chair, I move that we vote on the sufficiency of substance on the Sabalia et al. Complaint.
May we be given the opportunity to make it more accurate. We
Madam-
need to declare either sufficiency or insufficiency in substance of Sabalia et al. Complaint.
Madam
The
Chair-
Honorable Asidre.
Madam Chair, I move that we declare sufficient in substance the Sabalia et al. Impeachment complaint.
There is a motion to declare the sufficiency in substance of Sabalia et al. Impeachment complaint. The same has been seconded by the Honorable Tino and the Honorable Zamora. Do I hear an objection? No one is objecting?
Objection, Madam.
An objection has been registered by the Honorable Suntay, which means we will proceed to vote. Those who are in favor of the motion, please raise your right hand. Can you higher your hands just to make sure that the Secretariat will come up with an accurate counting? Secretariat, are you okay? Kong Dumogan is here and raising his hand as well. Oh, you may now put down your hands. Those who are not in favor of the motion, those who are not in favor of the motion, please raise your right hand. It's okay. Those who abstain, please raise your right hand. All right, so that concludes the voting. Secretariat, the result, please. For the record, the Honorable Renego just came and she is registering as well her vote for the affirmative. That is in favor of the motion. The vote of Arnan Panaligan is counted already per the Secretariat. With 54 votes in the affirmative, 1 in the negative, and 0 abstention, the Chair declares the sufficiency in substance of Sabala et al. Impeachment complaint. So ruled. Now we proceed to the 4th impeachment complaint, the Cabrera impeachment complaint endorsed by the Honorable Abante and the Honorable Ortega. The Chair is ready to hear the necessary motion.
Madam Chair.
The Honorable Rodriguez.
Before the vote, once again, I would like to ask. There are 5 grounds on the 4th complaint. This representation believes in the dismissal, no substance in 3, but 2 has substance. How do I vote?
Honorable Rodriguez, it is clear in the rules that we are voting on the entire impeachment complaint. The sufficiency in substance has to be determined on the basis of its entirety and not on the basis of the individual grounds. In other words, it's either you vote in favor of the sufficiency or not in favor of the sufficiency.
Madam Chair, I always agree with the Chair.
Thank you. The Chair is ready to hear the necessary motion.
Madam Chair,
The Honorable Zamora.
I move to declare the impeachment complaint filed by Attorney Nathaniel Cabrera as sufficient in substance.
There is a motion to declare the impeachment complaint of Cabrera sufficient in substance. Do I hear a second? The same has been seconded. Is there any objection?
Madam Chair, once again, objection.
The same has been objected to. We shall proceed to divide the House. Those who are in favor of the motion, please raise your right hand. Secretariat, are you okay? You may put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand. Those who abstain, please raise your right hand. That concludes our voting on the 4th impeachment complaint. Secretariat, result, please. with 54 votes in the affirmative and 1 vote in the negative, with 0 abstention, the chair declares the Cabrera impeachment complaint sufficient in substance. So ruled.
Madam Chair.
The Honorable Zamora.
In view of the finding of the sufficiency and substance of the 2 impeachment complaints, I move to issue notice to the Vice President or the respondent of the impeachment complaints to file her answer to the impeachment complaints within a non-extendable period of 10 calendar days from receipt of this notice. Thank you, Madam Chair.
There is a motion for the issuance of notice to Vice President Sara Duterte for the filing of her answer to the 2 impeachment complaints within the non-extendable period of 10 days. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is granted. The committee is directed to issue the necessary notice to the respondent. If there are no other matters to be discussed in this committee hearing or to be manifested by the members, the chair is ready as well to hear the necessary motion.
Move to adjourn, ma'am. Move to adjourn.
Our today's committee meeting is hereby adjourned.
Mag-subscribe at i-click ang notification bell para sa mga susunod na video updates. Maraming salamat po.